Hello and welcome to this presentation on common misconceptions about directors' duties. My name's Neil Stewart. I'm an Associate Director with Manolete Partners plc and I cover the south of the country from Thames Valley down to the south coast. Manolete is in the business of purchasing and funding insolvency litigation claims, and so breach of duty claims against directors are something we see all the time. There are many misconceptions in this area, and the ones I've picked out are those I've seen at least a couple of times. I am, though, mindful of my audience. As chartered accountants, you won't make some of the mistakes I've seen, but it might be helpful to know what kind of mistakes other people make, directors and so on. I'll go into more detail on that as we go through the slides. There's a health warning I have to give before we begin, which you'll see in the blue strip at the bottom of the slides, and it's that Manolete is an investment business. It's not a law firm and doesn't give legal advice. So nothing I say today amounts to legal advice, and it mustn't be construed as such. 3 quick points on terminology. Where I say he, generically, I mean he, she, or gender neutral pronoun. And where I say company, that generally includes LLPs. Thirdly, throughout the presentation, I'll talk about breach of duty claims or breach of duty rather than the practically synonymous term misfeasance, only because that's a particular feature of the way in which Manolete operates, so I won't go into that in any more depth. These are the areas I'll cover. First of all, the perfectly innocuous looking source of directors' duties, and as with each of the other subjects on the list, I'll identify common misconceptions first, then go on to explain the correct position or the true position. Limitation, as in when a claim becomes statute barred, law's complex on that, and so misunderstandings abound. Bounce back loans, we've given talks on this, and the last time I spoke on it, it lasted about an hour. Today, it'll be a few minutes. Unlawful dividends, which I'll deal with separately from the next subject, directors' loan accounts. The two are closely related because we're all familiar with the common practice in SMEs, at least, of director shareholders taking a small salary which doesn't exceed their personal allowance before becoming liable to pay income tax. Then they draw down additional payments through the year and declare a dividend at the end of the year to mop up those payments. Well, if there are no distributable reserves at the end of the year, then it doesn't matter whether the payments appear on the dividends ledger, because all that means is they were given that nominal code or whatever, and that doesn't make them dividend payments. They're probably more properly categorized as a loan, and that's where the two areas overlap in the main. Tax avoidance scheme, these tend to go back a long way and are becoming less relevant now, but it wouldn't be surprising if they were replaced with another clever way of avoiding tax. Enforcement, loads that can be said about this, but I'll focus just on pensions today, and then a couple of misconceptions about evidence to round off. Here are some misconceptions about the source of directors' duties. They come from common law, but they've all since been codified in the Companies Act 2006. All those duties are fiduciary duties, and they only apply while you're a director. As with many myths, there is some basis for those beliefs, so they're not entirely misconceived. Now, it is correct, of course, that a number of common law duties have been codified, and they appear in the Companies Act 2006, sections 171 to 176, and they're known as the general duties. And I'm going to put up a list of those duties which are owed to the company by de facto directors and sometimes by shadow directors, as well as by statutory or de jure directors. First, to act within your powers. Second, to promote the success of the company, and that's expressed to be for the benefit of its members as a whole. Section 172, subsection 3 expressly provides that the duty has the effect in certain circumstances to require directors to consider or act in the interests of creditors of the company. A great deal has been said about the Supreme Court decision in Res Equana about the point at which creditor interests intrude. All I'll say is that it's when the company becomes insolvent or is right on the edge of insolvency and is about to fall into it. But it's still a duty to the company, not a separate duty to creditors. There's a duty to exercise independent judgment, a duty to exercise reasonable care, skill and diligence. There's a fine line, of course, between actionable negligence and mere commercial misjudgment. The courts generally aren't keen to interfere with commercial decisions. Now, all the other duties I've mentioned so far, and those I'm going to come on to mention, are fiduciary duties. This one in section 174 isn't. So if the director has simply been careless and has only breached this particular duty, the remedies that are available for breach of fiduciary duties are not available here. Therefore, a company through its liquidator or administrator wouldn't be able to apply for injunctive relief, an order to set aside the transaction, an order for restitution, or an order for an account of profits. The only remedy available would be for damages for losses suffered. Then there are two duties which don't come to an end simply because you've resigned as a director. There's a duty to avoid conflicts of interest. A director must avoid a situation in which he has or can have a direct or indirect interest that conflicts or possibly may conflict with the interests of the company. And it's no answer to say that the company wasn't able to take advantage of the opportunity. That's unless the company has actually turned down the opportunity where that decision was fully informed, bona fide, and properly taken. So if you're advising a director or former director of a company and they're looking at, say, an investment opportunity for themselves, which they wouldn't have known about or wouldn't have been able to exploit had they not been a director, it's best to get unequivocal confirmation from the company that it's fully aware of the opportunity and has decided not to invest in it before the director takes further steps. The duty in section 176 not to accept benefits from third parties, that's a codification of the fiduciary rule prohibiting the exploitation of the position of the director for personal benefit, and that's a continuing duty as well. There is one other general duty which is in section 177, which is to declare an interest in a proposed transaction or arrangement with the company. I've left that one off because it's not something we tend to get involved in. As Mr. Justice Norris said in the 2015 case of Breitenfeld against Harrison, those statutory duties are not an exhaustive code. They don't supplant the common law and the equitable principles from which they're derived, but they do fall to be applied in the same way. So the pre-2006 law on directors' duties still applies. And I'll move on now to what those other duties are. In the case I've just mentioned, Breitenfeld and Harrison, these further common law duties are listed. There's a duty to account for the stewardship, or for the director's stewardship of company's assets, a director to apply company property under the director's control for the purposes of the company, and a duty not to make a profit for yourself as a director through the use of your fiduciary position. Nothing particularly controversial or surprising about those. But they can be useful when the situation you're looking at doesn't quite fit into the statutory code. These are a bit more interesting. There are duties on directors to inform themselves of the company's affairs and to join the co-directors in supervising and controlling those affairs. Directors also have a duty to maintain sufficient knowledge and understanding of the company's business to enable them properly to discharge their duties. These duties are about the collective responsibility of the directors, and what they do is confirm that it's not an option for a director to sit back and do nothing or to take no real interest in what's going on. There's an expectation that directors will meet and share the decision-making responsibilities. So where you have someone who brings another family member into the business as a director, be it their spouse, parent, child, or whatever, that person should be left under no illusion that they're taking on a pretty heavy responsibility, and they should also be aware of their potential liability if things go wrong, even if they took no active part in whatever wrongdoings took place. Moving on to limitation. Here are some misconceptions or partial truths. First of all, you have 6 years from the date of the breach to issue a claim. Well, that's one end of the scale. Going to the other end of the scale, there's no time limit for breach of duty claims. And then you have 6 years from the date of entry into liquidation or administration to bring a claim, which is somewhere between those two extremes. Each of those can be true in particular circumstances. None of them apply across the board. First of all, there are what might be termed continuing breaches. If, for example, a director has misdirected company funds, such as payments from customers into their own account, then there's an obligation to pay it back. And that obligation continues right up until the company goes into an insolvency process, and the failure to pay it back is a continuing breach. And I've seen arguments to the contrary along the lines of, well, this all happened 10 years ago. That's when any breach must have occurred. So you're time barred from bringing a claim. And yes, the particular facts of the case might get the director off the hook. But the point is that there's a danger in only looking back at events in the last 6 years. Another reason there's that danger is that Section 21 of the Limitation Act disapplies all time limits in the Act, so it's bad news for the director and good news for the claimant where that applies. Section 21, subsection 1 says that no period of limitation shall apply or no period of limitation in the Limitation Act shall apply to an action by a beneficiary under a trust, being an action either A, in respect of fraud or fraudulent breach of trust to which the trustee was a party or privy, or B, to recover from the trustee trust property or the proceeds of trust property in the possession of the trustee or previously received by the trustee and converted to his use. So it talks about trusts and trustees, but it's settled law that the fiduciary position of company directors to company property is the same as that of trustees to trust property. So where it says trustee, you can insert director. Where it says beneficiary, you can read company, and for trust property, read company property. Now, the first limb of Section 21 is Section 21(1)(a). That applies in the case of fraud or fraudulent breach of trust. So there has to be some dishonesty. So that can be difficult to prove, and it's more likely that a claimant is going to rely on Section 21(1)(b), although, of course, as a claimant, there's no harm in relying on them in the alternative, depending on the facts. But if there's no fraud, then the application of time limits only applies where the claimant is seeking the return of company funds or other property that's actually passed through the director's own hands. So if Director A has had all the money away and you're advising Director B, then although Director B might have breached his duty by failing to do anything about the misapplication or misdirection of company funds, if it happened more than 6 years ago, then he's safe. Or is he? Well, possibly not, and that's because the claimant might rely on Section 32 of the Limitation Act as well, or instead of Section 21. And Section 32, subsection 1 says, amongst other things, that if the claim is based on the fraud of the defendant, or any relevant fact has been deliberately concealed from the claimant by the defendant, or the action is for relief from the consequences of a mistake, then the limitation period doesn't start to run until the claimant has discovered the fraud, concealment, or mistake, or could with reasonable diligence have discovered it. Now, Section 32, subsection 2 adds that for the purposes of that subsection, deliberate commission of a breach of duty in circumstances in which it was unlikely to be discovered for some time amount to deliberate concealment of the facts involved in that breach of duty. Joe Curl, King's Counsel, has successfully argued in at least two reported cases that I know of that, by virtue of Section 32, the start of the limitation period has been deferred to the company's entry into an insolvency process. Now, you might think that as long as there's no fraud or actionable mistake, then the director only has to worry if he's deliberately concealed the action on which the claim is based. And that's correct, but if the director or directors have deliberately committed the breaches, and they're the only people who could have known about those breaches, then that can amount to deliberate concealment, because no one's going to find out about them until either the board is replaced or the company goes into administration or liquidation. The cases are Haysport Properties Limited against Joseph Ackerman, 2016, and the 2019 case of Pantals Investments Limited and another against Winkler. In the Haysport case, Mr. Justice Peter Smith said this: Mr. Ackerman has a positive duty to disclose his own breaches of fiduciary duty. He's failed to disclose those breaches, with the result that he has concealed the existence of the breaches from the claimant. And then, echoing what I said earlier about continuing breaches, the judge said, while Mr. Ackerman was a director, he owed a continuing duty to disclose his breaches of duty until he ceased to be a director. In the case of Re Pantiles, the judge said that the relevant action had been a deliberate act that constituted a breach of duty. It wasn't inadvertent. That act was done in circumstances where the breach of duty was unlikely to be discovered until someone other than Ms. Winkler took charge of the company's affairs. That was unlikely to happen until the company was placed in responsible hands on a liquidation. So there you have it. It might be that the limitation period is disapplied altogether, or it might be that the limitation period, which is generally 6 years in breach of duty claims, that it doesn't apply until the company enters liquidation or administration. But in cases where neither Section 21 nor Section 32 apply, then the limitation period runs from the date of the breach. Now, confusion with office holder claims sometimes creeps in here. In the case of a transaction as an undervalue claim under Section 238, or a preference claim under Section 239 in particular, the action can only be brought by an office holder or the assignee of an office holder, so the claim isn't complete until an office holder is actually appointed. And that means that the limitation period can't begin to run until the company enters an insolvency process. That doesn't apply to breach of duty claims, so the limitation period isn't necessarily deferred until the start of the liquidation. Finally, a word about latches. Some say laches, I say latches. Not heard about very much these days. It's an equitable defence or doctrine. A defendant who invokes the doctrine is saying that the claimant has been dilatory in asserting his rights, and because of the delay, circumstances have changed and it's no longer equitable to grant the claim. In other words, there has to be an element of unconscionability arising from the delay. It only applies to equitable claims, so it won't help a director in a straight claim for damages, but the principle is worth bearing in mind. And it's worth bearing in mind because claims never get better as they get older, because memories fade, documents are lost, and in the case of proprietary claims, the property might disappear. Moving on to bounce back loans, here's the main misconception. The company's breach of duty claims against its directors are all about the fraudulent application and obtaining of the loan. Now, the first thing to say about bounce back loans is that they haven't given rise to any new types of claim and there's no new law. I say kind of, because some adjustment was introduced. For example, the Company Directors Disqualification Act 1986, the powers in that were extended by the snappily titled Rating, open bracket, coronavirus, close bracket, and directors' disqualification, open bracket, dissolved companies, close bracket, Act. So the director of a dissolved company can now be disqualified, whereas previously the company still had to be lived. But generally, there's nothing new. In many cases, with bounce-back loans, the loan was obtained fraudulently, and I've seen several now where the company wasn't even incorporated until the end of 2019 or the beginning of 2020, but was still said by the director to have had an annual turnover of £200,000. So the reason for that, of course, is that the maximum BPL of £50,000 can be obtained. And they're not even subtle about it, like going a bit below 200,000 or a bit above. But that in itself, that fraudulent application, if that's what it is, doesn't amount to a breach of duty to the company, so far as I can see. Yes, the director might have defrauded the bank, but he hasn't defrauded the company. And even if it did amount to a breach of his duties to the company, it didn't cause any loss to the company because the effect is balance sheet neutral. Where the loss occurs is in the misuse of company funds. It's coincidental that those company funds originated as a bounce-back loan. And whilst it's helpful to be able to show that they were obtained fraudulently in the first place, that sort of paints the picture. To succeed in a breach of duty claim against the director, the claimant has to show that he misapplied the funds, very often simply by paying them into his own account and using them for non-company purposes. And the misapplication can amount to breaches of sections 171, 172, 174 and 175 and certain common law duties. Unlawful dividends. Here are some misconceptions on the part of directors. We've made a profit this year, so we can pay a dividend. Another one, we can decide whether withdrawals are dividends or salary after the year end, and sometimes they're encouraged in that belief by those who should know better. And you can't come after me for dividends received by other shareholders. You can only come for what I've received. Well, let's move on and see what the true position is. On the profit point, Section 830 of the Companies Act says that you can only pay a dividend from distributable reserves, which is the company's accumulated profits less accumulated losses. Now that's pretty obvious, but it's a mistake that's made quite commonly by company directors. They see a profit in a particular year, they think they can take it. Well, it doesn't matter whether the company has made a profit in a particular year. If it's in deficit, then it can't lawfully pay a dividend, and that needs to be determined by reference to relevant accounts. Where the company's filed accounts for the end of the period show a deficit or insufficient reserves to pay the kind of dividend the director shareholders are looking for, then there'd better be management accounts showing distributable reserves at the time the dividend was declared and paid. And just a word on that, where a dividend is declared lawfully, but by the time it comes to be paid, the company's in deficit, then the directors might find themselves in difficulty further down the line if they nevertheless just went ahead with the payment of the dividend. It's now settled law that you can't later reclassify a dividend as salary. Loads of case law on this. I'll pick one case, Global Corporate and Hale, 2018. The Court of Appeal confirmed that the lawfulness of a dividend or other distribution for the purposes of Section 830 is assessed at the time it's made. Recharacterising it after the event as another form of payment isn't possible. The misconception about only being able to chase the shareholder for whatever they've had in dividends is a misunderstanding about the nature of breach of duty claims. Now, it's true that the company can only reclaim as a debt whatever the shareholder has received from that shareholder, but directors mustn't be under any illusion. If they have caused the company to pay dividends unlawfully, then they can be jointly and severally liable for the total sum paid out to all shareholders. And that's, of course, subject to any defence that they have, for example, about having been fraudulently misled by another director. But they have to remember that they can be jointly and severally liable for the lot. Moving on to directors' loan accounts, misconceptions include where directors think that because there's no formal loan account, and so far as they're concerned, they haven't borrowed any money, there's no DLA claim. And another misconception is that the burden of proof is always on the company or the office holder to prove that funds were misapplied. The first misconception is simply where the director is confusing form with substance. An example would be where the director has been taking so-called dividends, and for one reason or another they can't be properly classified as dividends, and then they're simply drawings. And these are more properly characterised as a loan, and they have to be repaid as a simple debt to the company. Now, the debt claim can only be for the amount the particular director has borrowed himself. But allowing yourself and your co-directors to run up a debt without doing anything about it, particularly if there's no realistic prospect of repayment, can amount to a breach of duty. And it comes as a genuine shock to some directors that they can be liable for both their own DLA and that of their co-directors. Some don't believe it, and they continue not to believe it until proceedings are issued, and then they belatedly seek legal advice. Of course, it may seem very unfair that the claimant is going after the director with the deepest pockets, or the only solvent director or directors, but that perceived unfairness doesn't amount to a defence, of course. Sometimes you have a situation where one director has a heavily overdrawn DLA while another is substantially in credit, and an attempt is made by the directors to set off one against the other post liquidation. And that's not possible because under the insolvency set-off rules, which are Rule 14.24 for administration and 14.25 for liquidation, there's a requirement that there be mutual dealings between the company and that particular creditor. So it means that the company's debt to creditor A is to be set off against creditor A's debt to the company. It's a mandatory rule. But that set-off occurs so only the balance is provable in the administration or liquidation, but there's no provision for the company's debt to creditor A to be set off against creditor B's debt to the company. I should just mention that in the case of liquidation, the right of set-off takes effect automatically from the date of liquidation, but in administration, the right only takes effect when the administrator gives notice, or if or when the administrator gives notice of the distribution to creditors. I should also mention that a director may not set off debts owed to him by the company against his liability to pay compensation for misfeasance or breach of duty. The case there is Manson and Smith as liquidator of Thomas Christie Limited. That's 1997. So no set-off available against liability for breach of duty claims. Last bullet point on the slide, directors are sometimes under the illusion that the onus of proof is always on the office holder. In the case of Re Mumtaz Properties Limited, that's Wetton and Ahmed, 2011, the former directors appealed against a finding as to their personal liability for directors and other loans. The liquidator in that case had undertaken a reconciliation and identified a figure for each director's overdrawn loan account. And the directors said, yes, but if you'd had a full set of papers, you'd see that we don't owe that money because, in fact, it was used for proper company purposes. Well, the problem for the directors was that the documentation was inadequate and the judge didn't have to accept their oral evidence. The Court of Appeal upheld the decision of the judge at first instance, and the lesson is that directors can't rely on their own bad bookkeeping or poor records as an excuse for being able to show or being unable to show that payments were made for proper purposes. And this is what was said in the Court of Appeal. The approach of the judge in this case was to test the evidence by reference to both the contemporary documentary evidence and its absence. In my judgment, this was an approach that he was entitled to take. The evidence of the liquidator established a prima facie case, and given that the books and records had been in the custody and control of the respondents to the proceedings, it was open to the judge to infer that the liquidator's case would have been borne out by those books and papers. It was not open to the respondents to escape liability by asserting that if the books and papers and other evidence had been available, they would have shown that they were not liable in the amount claimed by the liquidator. Moreover, persons who have conducted the affairs of limited companies with a high degree of informality cannot seek to avoid liability or to be judged by some lower standard than that which applies to the directors, simply because the necessary documentation is not available. That approach has been applied consistently in later cases, and it's a salutary lesson to directors, at least, that they can't have it both ways. Tax avoidance schemes, as I said, I'll deal with this in short order. These are the misconceptions. The schemes and participation in them were unlawful. The company's claim is for the tax liability arising, and you did nothing wrong if you followed the advice given through the scheme promoter. The first misconception isn't helped by their being called disguised remuneration schemes, which suggests something nefarious about them, but they were perfectly legal schemes and there was nothing necessarily fraudulent in using them, which is not to say that in particular circumstances fraud might have been involved. The particular form the scheme took, whether it was an EBT, an EFERS or some other device, doesn't really matter. They were all highly artificial structures, and they were set up to allow cash to be extracted in some way or another from the company without having to pay tax, or that was the hope at least of the directors at the time. The important thing is that the company's claims are not to recover unpaid tax. HMRC might seek to recover unpaid tax from the director, but that's not part of the company's claim, which is for breach of duty through misuse of company funds. The loss suffered by the company is the cash that was extracted to pay the director through the disguised remuneration scheme, not the tax liability arising as a result. Now, that has consequences for the type of claim that's brought and how it's pleaded. From the director's point of view, the important point is that the office holder will be seeking the whole of the sums extracted via the schemes, not just the tax element. Where the relevance of the tax liability does come in is in its effect on the company's solvency. The liability to tax arises when the funds are extracted. That was confirmed by Chief ICC Judge Briggs in the 2019 case of Re-Implement Consulting. The tax liability doesn't arise later when liability is assessed or notified. Very often what happened was that the directors took large sums through the tax avoidance schemes without making any provision for the tax that might arise, and the company became insolvent as a result of that tax liability. So they were taking funds from a company which then was insolvent. Now, a common defence put forward is that they didn't have to make any provision according to the relevant financial reporting standards, but that's a matter of accounting, and it's still likely to be a breach of duty for directors to use these schemes, and highly likely to be a breach of duty if they continued to use them while they were on notice that they might not give the tax advantages that the directors were hoping for. As to this scheme documentation, I can use a metaphor borrowed from Joe Curl, KC. This is the snake oil salesman telling you that the snake oil definitely works. Not only that, but the advice in the schemes and documents is generally heavily caveated. And if it refers to a QC's advice, as some of them did, then it tends to be highly selective. For the directors to have an effective defence that they relied on professional advice, they're likely to have to provide evidence that they received and followed advice that was genuinely independent. On enforcement, I said that I was going to focus just on pensions, and the main misconception I want to look at is that a liquidator or administrator can't touch a director's pension. Now, it is correct that pensions enjoy special protection under the law. First of all, a debtor's pension is protected in bankruptcy. I'll explain that second bullet point in a moment. The second way in which pensions are protected is that under Section 91, subsection 2 of the Pensions Act 1995, no order can be made by a court which restrains a person from receiving their pension under a registered occupational pension scheme. In the 2012 case of Blight and Brewster, the debtor had tried to argue that the special treatment of pensions in bankruptcy meant that they should be protected from enforcement outside bankruptcy as well. Well, the late Gabriel Moss QC, sitting as a Deputy High Court judge, rejected that argument, and he said effectively that you can't have the benefits of bankruptcy without its considerable burdens, as is mentioned in that second bullet point. Mr. Moss also decided that an injunction could be granted over a debtor's power to draw down their pension. That principle has been applied several times at first instance, and the jurisdiction to do so was confirmed by the Court of Appeal in the 2022 case of Batchy and Green. But it wasn't until the 2023 case of Manolay and White, managed to get one Manolay case in there, that the Section 91 point was properly tested. Manolay invited the court to follow obiter comments in Batchy and Green made by Mr. Andrew Hockhauser QC, sitting as a Deputy High Court judge, which distinguished between, on the one hand, restraining receipt of a pension, which Section 91 of the Pensions Act says a court can't do, and on the other hand, being compelled to do the very opposite, namely to receive the pension rather than having it remaining trapped in the fund. The sting in the tail for the debtor is that the compulsion to receive the pension can be coupled with the requirement to apply it in a particular way to pay debts. So there you have it. It's a fine distinction, you might think, between being restrained from receiving your pension and being compelled to receive it, but handed over to someone else. But that's the law as it stands. My final topic is evidence, and misconceptions abound in this area. Here are just two of them. If a witness has no supporting documents, he has no evidence. Now, it might be surprising that I call that a misconception, given what I said earlier about re Mumtaz, but the point here is that I've often heard people say he has no evidence, when what they actually mean is he has no supporting documentary evidence. And sometimes oral evidence alone can be enough, depending on the circumstances, the credibility of the witness, and perhaps any corroboration from another witness. Another one is documentary evidence trumps oral evidence, or oral evidence trumps documentary evidence. You have to use the word trumped judiciously these days. I'm using it without any illusion. The first point is that oral testimony is evidence. In the dim and distant past, it was regarded as the best form of evidence. The pendulum has swung the other way, rather, in commercial cases at least. But it would be a great mistake to disregard the evidence of a witness just because it's not supported by documentary evidence. Now, a lot of time is saved in court these days by having witness statements verified by a statement of truth serving as evidence in chief. But if you sign a witness statement or verify any document by a statement of truth, then you must be prepared to be cross-examined on it. Of course, you're required to include in a witness statement the source of your knowledge, so there's an opportunity to qualify what you're saying, but ultimately, if you're not prepared to attest to the court what you said in the witness statement, or you're not prepared to be cross-examined on it, then you mustn't sign it. The reason documentary evidence tends to win when it's inconsistent with witness evidence is this. It's all about the frailty of human memory and, probably more importantly, a common tendency to reinterpret or rewrite past events. The more we learn about how memory works, the more we understand how even perfectly decent people might do exactly that, whether that's through embarrassment or cognitive dissonance, where two lines of thought don't quite match up, so you reinvent the facts to reconcile them. And it can be as simple as thinking, well, I'm an upstanding, honourable person, but you've done something reprehensible. And in the process of reconciling those two things, you end up convincing yourself that it didn't really happen that way. And it's not just oral evidence that can be problematic, though. Documentary evidence can be inaccurate, unreliable, or misleading, but there's a particular power in contemporaneous records, especially where they've been kept as a matter of routine by an independent third party, because, well, why would they be wrong? The final point I'd like to make is about litigation risk. You never know how the evidence will come out at trial. Good witnesses can turn bad and bad witnesses can turn good. So when counsel advises you that you have a 65% chance of success, by the way, that's about as high as ever you're likely to get, you just have to remember that there's a 35% chance that you'll lose. That brings us to the end, so I hope you found this helpful. Thank you for listening.